Good morning, I'm Tiff Lynch, Acting National Chair of the Police Federation of England and Wales.
Morning, Dan Murphy, Assistant National Secretary from the Superintendents Association.
Thank you. I call Matt Vickers.
Hi. It's a huge, broad bill with lots of measures and powers being brought forward, hopefully welcomed by all those brave men and women that you represent. Having looked at the bill, is there anything that you find concerning? Is there anything that you see as possible to improve? And more broadly, is there any measures that you'd have liked to see in the bill that aren't there?
Thank you. No, the NPCC doesn't see any measures which we think have been omitted, save perhaps for the provision on begging, which I think was in an initial draft, but we understand concerns there in respect of how that might be enforced. Overall, the NPCC is extremely supportive of the bill. It seems to us that it brings a lot of the laws up to date and frames the law in a way which is much more consistent with the way the law of crimes are now committed and enables generally much earlier intervention and also prevention on the back of the new or adapted offences which are created.
And could you just comment briefly on begging and what you saw as something that you saw coming forward to reform, where you'd like to have seen this if we did include anything to that end?
Yes. So I think the point in respect of begging was that whilst we were generally supportive of the inclusion of nuisance begging in the provisions, it was reflected that it would require a certain amount of judgment in how to enforce that. So that's the only point that NPCC colleagues have noted that was in the original provisions, which isn't here. Other than that, they were extremely supportive.
Thank you. In relation to the overarching bill, we concur with Chief Constable de Maire that we are supportive of new legislation that brings us up to societal issues. Rather than not sounding like a broken record throughout all of the questions here, our main concern will be the infrastructure that sits behind legislation, the demand that is placed upon our officers that we represent that will actually be out there on the streets enacting this legislation, resourcing and the learning and training development of those officers that will be required to carry out.
Thank you. Yes, from the Superintendents Association, we also support the bill and the provisions within it. With any legislation, there'll obviously need to be clarity through the courts or through training or guidance that comes with the bill. And I've read with interest some of the debates for and against some of the clauses in the bill. So the power of entry with regards to electronic devices, public order, some of the definitions aren't defined within the legislation. And there's a specific concern that I've read, and it might not be a concern, but it's something that I read with regards to mandatory reporting clauses 45 to 54 and whether or not the covert nature of policing would be dealt with through an exception or through some kind of exemption with regard to that route.
Just on the entry without a warrant, obviously it's drawn more tightly, more narrowly in this bill than it was in the criminal justice bill. Do we think it gives you the tools you need to do the job, or is there any concerns about that?
I think it gives you the tools to do the job, but whenever you're entering private homes, you've only got to look at the case law on warrants where we have got full powers. They're challenged regularly, so we need to make sure we're trained, we get it right. But as it is a new bit of legislation, I'm sure there will be challenges either way as to when it's used.
And just any other comments on that entry without a warrant and it being narrower in this bill or otherwise?
I think there's a role for government and Parliament to communicate that that is a power that's been given to policing, and it's not something that policing is searching for and we're trying to use it. So the public needs to understand that's been given to us for a reason and where they're using it.
Yeah.
And if I may go one step further as well, in relation to the public having that knowledge of the powers, it's also to have our police officers to have the confidence that government are behind them when they are actually enforcing these laws. so that they know that they are supported in what they're doing.
Yes, thank you. So we know that the ability to track mobile devices isn't sufficiently at the moment accurate to enable it to be relied upon without some form of corroboration, and therefore one understands why things are more tightly framed. But where there is good intelligence for its use, this ability to enter swiftly to search for stolen goods without the need to get a warrant is going to mean that we're able to recover stolen property more swiftly. It means that investigations are less likely to be frustrated. Obviously, to ensure legitimacy in the eyes of the public, that needs to be carried out carefully. But overall, it will make it less likely that property is going to be swiftly capable of being disposed of, whether that's electronic property or property linked to rural crime. And our inability currently to deal expeditiously with those sorts of crimes can impact adversely on public confidence. So overall, a very positive operational thing.
Happy?
I'll call Dame Diana Johnson.
Thank you, Dr. Alan Carr. Thank you very much for giving evidence today. I wanted just to follow up on the questions that you were just being asked then about the recovery of digital devices that have tracking devices in them and allowing the police to go in without a warrant. Could the actual legislation says reasonable grounds to believe, that's the test that would have to be applied, and requiring authorisation by an inspector. I just want to check with each of you that you think that is the appropriate test and authorisation level.
Well, the requirement of belief is obviously a relatively high bar because it's above, for example, suspicion. I think that reflects the need to ensure that a new power such as this is applied carefully and with appropriate corroboration. And an inspector, crucially, is going to be readily operationally available for an officer in those sort of dynamic circumstances to make contact with and get the authorisation from, because it seems to me that the thrust of the power is very much towards enabling the police to recover property quickly. So it seems that the belief is a good safeguard, the inspector is appropriately senior and accessible, so I would agree with those 2 points.
Any of the other panel members wanting to comment on that?
I just think we need to make sure we've got the right training, guidance, and because of the power that we have to expect challenge, there will be challenge. My reasonable ground to believe may be different to somebody else's around the table. We would have gone through a process of using proportionate, necessary and justified means, looking at the intelligence, evidence and what's in front of us to form that belief, but that's something different for everyone, so it's not a black and white answer with regards to how that will be decided.
But inspector level authorisation, you think is the appropriate level?
Yes.
Yes. Okay. And
Good morning, Minister.
Yes.
I would agree with both Mr Demare and Dan Murphy on that in relation to the authorisation level. Again, I would say that we have to manage expectations in relation to victims of crime where we have locations identified and the demand that is already placed on our officers that are out there as to how speedy that recovery of that technical equipment will be made. It's about managing expectations also.
thank you. I just want to talk to you now about respect orders, and the bill will introduce respect orders for the most persistent adult offenders of antisocial behaviour. And I just wondered if each of you could say something about how these new measures will help and enable the police to tackle antisocial behaviour more effectively.
Yes, thank you. So we think the new powers, placing as they will requirements on those who've committed ASB, including positive requirements to carry out certain actions, will give us rather more flexibility in dealing with this type of behaviour. It's also preventative and restorative in some cases as well. We think the deterrent value will be greater. And also making a breach of the order a criminal offence allows us then quickly to arrest where there hasn't been that compliance. Overall, the NPCC thinks that this will enable earlier intervention. We know the very serious effect that antisocial behaviour has on community confidence and on the ability for people to engage in educational, social and economic life. So anything which enables us to deal more swiftly with problems when they're in their infancy is to be welcomed.
Do you want me to go? Thank you. Again, without repeating, we agree perpetrators can be required to address the root cause of the problems, obviously once dealt with. Again, I come back to resource and demand, certainly on the arrest element. Whilst we have perpetrators going into custody, that places a huge demand on the custody department, on police officers. We need the infrastructure that is placed behind it. And we're already seeing, certainly on custodial sentences as well, with the criminal justice system, a backlog of cases, and then with prison spaces already overcrowding. We need to have the infrastructure behind this to be able to actually make it effective and believable.
And the commitment to the 13,000 neighbourhood police officers to work in communities, in high streets, in town centres, to tackle some of this antisocial behaviour, that links together, I think, quite well. Would you agree with that?
Yes, it does, Minister. But I also come back to the time and it's the follow-on processes. Once you've actually dealt with a perpetrator, it's the hours that is spent with the paperwork and the systems following that. That could wipe out our neighbourhood officers in one shift. And sadly, until we get that infrastructure and the systems that back up any law, and certainly with these new laws, demand and all the other priorities could wipe out those additional officers in one shift.
Okay. Would you like to say something from the Superintendents Association?
Yes, I think there's it's come under the banner of antisocial behaviour, which it is.
Yeah.
A lot of antisocial behaviour issues that police deal with are for those that are under the age of 18. This applies to those 18 and over. I think the power's good, but if the public think we're going to be able to use this for teenagers, obviously it is going to be there's going to be a mismatch there. I think the power of arrest is good. I do note that there is a requirement to give a warning if there is a positive requirement in the respect order, which the public again might think that the respect order has been issued, you can just go out and arrest the person. Actually, you can't. So there are a few caveats to make, obviously, the law fair and people understand what's happening and those that are subject to them. I think the power of arrest will be extremely useful. But as Tiff said, someone's got to go and make that arrest, and then someone has got to put a case file together to prove the breach. So there is work to be done and resource to be put into this, so it does need to be resourced if it's going to be successful. But I think the main point is that it is for over 18-year-olds.
Yeah. And can I just ask about the new retail offences that are in here in terms of assaults on a retail worker and the threshold, the £200 threshold being removed? I wondered how both of those will assist policing in dealing with what we've seen, this spike in shop thefts over the last few years?
Yes, thank you. When I appear at community events, I often find this £200 point is a source of great confusion and misunderstanding. So to resolve that ambiguity is extremely welcome, as it's wrongly been supposed that somehow shoplifting under that threshold is legal, which plainly isn't the case. So to resolve that ambiguity is a good thing. On the point of an offence of assaulting a retail worker specifically, I think this acknowledges the vital role that retail workers play in community and local economic life, and the disproportionate likelihood of their being assaulted in the course of their work. By creating this offence, it enables us to identify much more precisely the extent of the problem, and it also enables us to deal with the crime in circumstances which the law much more closely reflects. So it's certainly welcome from our perspective.
Thank you.
Minister, I'd like to focus on the assaults on retail workers. We support this. Nobody should go to their place of work with the expectation that they're going to be assaulted. Absolutely nobody. Again, it comes down to resourcing, but I would also, I think it's worth mentioning that the same principle was applied for the assaults on emergency workers only a few years ago. It's something that was championed by the Police Federation of England and Wales. Unfortunately, due to the backlog within the criminal justice system, we've now seen that that legislation isn't being used effectively, and actually the assaults on emergency workers legislation they're now reverting to assaults on police constables. So if we are going to be bringing in this law, we need to see strong execution of it and the support for retail workers in the same way for emergency service workers.
Okay. Mr Murphy, do you have a view on this?
No, nothing further.
Okay. If I may, just one more question. Could I just ask Tiff Lynch about the proposed changes to the IOPC's referral threshold? And I wondered if you could just say the view is that will probably result in fewer referrals to the CPS around misconduct. I just wondered, could you explain why that's going to be beneficial?
Simply, in relation to time, the length of investigations. For far too long, the length of investigations has been an issue for police conduct. We expect that officers that do not uphold the warrant that they carry should be exited from the organisation swiftly. And those referrals will cut down on that time that we can actually have those investigations dealt with, which essentially will prevent any disillusionment from the public or from the complainant or victim, excuse me, I'm losing my voice, but also for the officer concerned.
Thank you. And so your view is that it will speed up proceedings?
One would hope.
But the threshold, the change in threshold, you support that?
Yes.
Yes. Would either the other members of the panel like to say anything on that?
Yeah, we would support that as well. Superintendents Association would support that change.
Right, thank you.
Lovely. Now call Luke Taylor.
Thank you, Madam Chair. And thank you very much for joining us to assist us with the bill today. I'm going to look at the clauses around concealing identity. So clauses 86 to 88, making an offence for someone to conceal their identity at certain protests. The current challenge we have around this is concerns from Hong Kongers, particularly my community, my constituency of Sutton Cheam, who are attending protests against the Chinese transnational repression in central London. They have concerns that their identities will be monitored by the CCP and then that used to conduct repression on family and friends in Hong Kong and in China. Obviously, protesting is incredibly important, that we're able to exercise our rights in a democracy to demonstrate our displeasure with whatever it is. What are your understanding of how a protest is defined? In what situations would a protest have these measures imposed? And how would somebody at one of those protests, and a good example to use is these Hong Kong protests, these Chinese protests, how would somebody be treated by officers if a designation was put in place and they were concealing their identities at these protests?
Well, it's extremely challenging to give a definitive answer as the question implies. So on the point of the definition of protest, first of all, there is, of course, no single definition of protest. There are a broad range of activities which could qualify as a protest, from one person, a gathering, a vigil, a march, the playing of music, chanting, or other sorts of circumstances. So it is a very challenging area of law and operational policing. On the point of concealing identity and the potential threat to safety in respect of transnational repression, I'm afraid, again, my response is going to be not quite as definitive as might be hoped for. We would have to apply the same judgment as we do in other areas of public order operational life, such as in relation to searching. And that means if an offence were suspected of being committed, it's for the officer to engage with the individuals in question and then to carry out a dynamic investigation of what's going on, seeking expert tactical advice where appropriate, or also senior authority. And it's important to point out that this doesn't say the power has to be used. It's what may be done, not what must be done. So it does very much come down to circumstances and the engagement and the judgment of the officer, and the advice in question is going to be vital. One would expect sensitivities such as this to be addressed through the training of the various public order operatives, the gold commanders, the silver commanders, the bronze commanders, and the public order officers themselves, and inevitably there will also be some learning through case law as well as it emerges.
I would agree with Chief Constable. I come back to what I said earlier on. This is in relation to training and learning. The law, the confines of the law, and police officers out there during protests work within the confines of the law. They utilise the national decision-making model, and it's all about what is faced in front of them on that day. We pride ourselves on people being able to protest lawfully, and it's within those laws and the confines of the laws and how those officers act on the day and what they're presented with. So it would be determined on the day.
It's a long time since I've run a public order operation, but I think as a police officer and a commander, and we talked about neighbourhood policing, it's about talking to people.
Yeah.
So if you're presented with what you as the commander think is a protest and you think you can justify that, if you haven't got a protest that's going to cause any particular problems, why would you go down this route? Even to do a preventative thing, if you have got people there that are covering their faces and you think there is this issue that you're raising, you may just send an officer to go and speak to them, say, would you mind just identifying yourself so we know who you are, and you deal with it by talking to people.
Am I able to have a small follow-up? Thank you, Madam Chair. Just as a very brief follow-up, do you think the new powers in here are necessary? Do they allow you to do things that you wanted to be able to do at previous protests but not been able to?
But it's an extremely good point in respect to the judgment which the officer would exercise. There have plainly been circumstances where people have concealed identity as a means of escaping detection, and frustrated the efforts of the authorities then to identify those who are responsible for offences within those protests, and in so doing meant we weren't able to prevent further criminal activity. So I think they're necessary, but they're to be exercised with caution and good judgment.
Many members have caught my eye, and in the interest of time, I'll only be able to get everybody in if members wouldn't mind keeping their questions very brief, if possible, please. I'd like to call David Burton-Sampson.
Thank you very much, Chair. My question is probably to you, Chief Constable de Mayor. Looking at knife crime, just thinking operationally, there's the new offence of possession of a knife or offensive weapon with intent to use in unlawful violence. Can you explain operationally how that perhaps bridges the gap between the current legislation of simple possession and using a bladed article or offensive weapon to threaten or harm somebody? And how is this going to help us to drive down knife crime?
Yes, certainly. So this allows for greater sanctions against those who are evidence as having or is known to be intending to cause harm. I think the important point here, it goes to the point I made at the beginning, in that the law will now more closely reflect the circumstances of the case, because the totality of the circumstances can be had to regard to when the investigation is being carried out, when the case is being presented at court, and ultimately when the sentence is being passed if the person is convicted. Because rather than relying only on the simple act of possession, the investigation and the court can have regard to the intent of the individual and the much greater seriousness of the circumstances which that implies. It also means that we'll be much better able to deliver what we term sustained public protection, because rather than simply bringing someone to justice for possessing a knife without being able to adduce evidence as to what their intention might have been, we can now adduce that evidence and what imagines come up with a tougher sentence which has much more preventative power.
Thank you.
Just to say that if the witnesses are in broad agreement, it's fine if only one person wishes to answer, unless there's something else they'd like to raise. I now call Harriet Cross.
Thank you very much, Ms. Alana Khan. If I can go back to Mr. Murphy and just pick up on the point on under 18s and respect orders. What sort of age would you like to see or think that it would be beneficial for that age limit to be reduced to, if that is what you were saying? Is there a particular age group where we see sort of prolific sort of antisocial behaviour starting to become more apparent? And also on a slightly wider point, do we think within the bill the definition of antisocial behaviour is wide enough? It says that Part 9, or Clause 9, means conduct that's caused or likely to cause harassment, alarm, distress to any person. My direct point being, is it being therefore restricted to person, or does it include instances where you have, for example, neighbourhood or property nuisance where it's impacting sort of on a larger scale but no single identifiable person can be attributed to being recipient of it?
I think on your first point, it would obviously capture more incidents and more issues if it was at a lower age. However, would we want to be criminalising children as such with this type of offence? So there's a balance, and I think it's a matter for Parliament and society as to whether or not they would like to lower that age. I can understand why it's been set at 18, but I just wanted to make the point earlier on that as it is at 18, that power would not be able to be used for young people. With regards to harassment, alarm and distress, and that's a person-specific issue compared to a community or area, I think in policing, if we could have something that would capture that as well, we would welcome it. But again, it's an extension of powers, etc. And it's about, you're putting me on the spot here, I'm thinking, how would you prove that? Who would be your witness or your injured party for a community? So putting me on the spot, I think what's provided at the moment is useful. Would it be good if it could be widened? Yes. Practically, could it be widened? I think we'd probably need a whole other committee and some lawyers to discuss that one.
Thank you very much.
Matt Bishop.
Thank you, Chair. First, I'll just take a moment to thank the panel and your colleagues for your service and continued efforts in making our community safer. I think it's important to recognise that. My question's around the measures that we're looking to implement to provide more protection against the retribution for the authorised firearms officers facing criminal proceedings for the offences related to and committed during their duties. Do you think the measures will reassure firearms officers that the government values the unique and dangerous work they do and give them more confidence moving forward to what we've experienced recently?
Yeah, okay. So it's important, first of all, to point out how rare it is in this country for a firearms officer to discharge their weapon, and rarer still, reassuringly, that someone dies as a result. Obviously, it's right that there's a proper investigation wherever this happens. I don't think it's in the interests of public safety for an officer doing such an important job to feel inhibited from doing what might, in extremely rare and extreme circumstances, be necessary and what they're trained to do, because they have a concern that in a subsequent investigation their name is going to be made public with all of the risk that entails to them personally. I can't say for certain colleagues here I would give a better indication as to the extent that this might assuage their concerns, but it seems to be a necessary and sensible move.
Without repeating Chief Constable de Mayor, certainly we were pleased with the Home Secretary's announcement in relation to the anonymity of firearms in those situations, and certainly for NX 121, the incident and the case that followed. Our firearms officers are volunteers, and that is key, and it really needs to be noted that they are volunteers, that they put themselves at risk, they put their lives at risk to protect society. And in cases where this is concerned, for their families and for their own well-being and what may follow on from that, it's only right for the anonymity aspect of that to be placed upon them for a period of time that is required. So yes, to answer your question specifically in relation to the reassurance of our firearms officers that are out there today, there is some reassurance, but again, it's a matter of time that they actually feel that that is going to continue.
Mr. Murphy?
Yeah, it's definitely a step in the right direction. Firearms officers, local police officers are interested in actions rather than words, so they would like to see a difference. So I think once they start seeing that difference, that will make a difference to them. And I know that the accountability review is going, there's going to be some announcements on that soon. Dame Diana, I think, is involved in that. So I know the government are looking at it, and we're really encouraged that there may be some more positive steps that will lead to actions that support officers that put themselves in those most difficult situations.
Thank you. Thank you, Chair.
So we know that a small number of people are responsible for a huge volume of the crimes that we're discussing. Do you believe there are sufficient powers to deal with hyper-prolific offenders and imprison them? Do you think we should be doing anything in that space? I'd also be interested in the other two panel members' views on the 80, 60, whatever it might be question as well.
So to answer your question in relation to the powers, this is something that I find myself repeating, not in this forum, but in other interviews. The law, you can bring in as many laws and powers. We need to have the infrastructure, we need to have the resources. We've got officers that are out there with case files that are getting longer and longer and longer. And there is only so much that can be highlighted as a priority, and if everything's a priority, then nothing's a priority. So yes, we support the laws, and it's for government to make the laws, it's for us to carry them out, and we will do so. But it's about that managing expectations, not just from policing, but also from society.
In terms of hyper-prolific offenders, do you think, obviously a lot of time being taken by a small number of people, do you think there's anything we can do in that space to make the job easy?
You can do if you want to.
If you've got someone who's a prolific offender and the police are constantly dealing with them and you've got constant victims, the best place for that person is in prison. Getting them into prison is sometimes not easy. So I think that's the answer.
Just a reminder, we need to keep things really short if we want to get everybody in. It may not be possible to do so. Lauren Sullivan.
Thank you, Madam Chair, and thank you again for joining us today. I just wanted to pick up on your views on the new kind of youth diversion orders and the youth injunctions and how that can be supporting ASB in our communities. Just your thoughts on those, please. Thank you.
Are you just ASB or counter-terrorism?
Bit of both. So we've got the youth injunctions, which could help with the ASB, certainly in our communities, but then equally how the youth diversion orders kind of intercede and intersect.
Yes, and I agree that there is an intersection between the two. So counter-terrorism policing are certainly extremely supportive of youth diversion orders. Interestingly and concerningly, there has been a significant increase in the number of young people featuring in the casework of counter-terrorism policing. In 2019, just 4% of those arrested for a counter-terrorism offence were aged under 18. By 2023, this is 19%. And this poses serious challenges, not just in respect of the threat, but also caseload, and naturally counter-terrorism policing wants to avoid, wherever possible, criminalising young people at a very early age who might themselves have been exploited by extremists. So these orders, it's felt, will help to divert young people away from being labelled a terrorist, if I can put it that way, and engaging in further offending. It opens up the possibility of some supportive and prohibitive measures. So there's both a carrot and a stick, as you might put it. And it just enables colleagues to manage the risk at a much earlier stage than is currently the case. On the matter of prevent, which of course is long-standing, that has been essentially voluntary for young people, and there hasn't been any means to compel their involvement in the necessary diversion. We see this measure as a means of introducing just about the right amount of compulsion to that prevent set of activity without making it entirely mandatory.
Joe Robertson.
Thank you, Chair. If I could take the panel back very briefly to the powers around face coverings in protests. Given that protests are often political in nature, does anyone on the panel see challenges presented by having to exercise that power and challenges around perception or accusations of political bias? I just wonder if I could have some reflections on the challenges that having to exercise that power will create in that field.
So I think it's important to emphasise, first of all, that we won't have to exercise the power. It's a power which is open to us, which we may use, not necessarily that we must use. That having been said, of course, one accepts entirely the potential for people on one side of a debate to suggest that the power ought to have been used and that it hasn't been used on another side. I can only say that that is for commanders in each individual circumstance to ensure that they are trying to abide by the principle of policing without fear or favour, and doing so impartially. It's difficult for me to say much more than that because there are so many circumstances in which it might come to pass, but I do envisage the difficulty.
I'll keep this very quick for you. It's down to interpretation. I also think it's relevant with communication in terms of how the general public have an understanding of what police officers are out there doing. We're seeing actions of police officers on these protests being placed all over social media. It's a snippet of information, so as a result we get misinformation and disinformation, which then heightens society's frustration. So I think there is a role to play for everyone, and certainly within government, to actually communicate those powers and the actions to the public so that everyone has that clear understanding. And then it's again to have the support, certainly for the officers that we represent out there on the front line in doing what they're doing.
I'm afraid this will probably have to be the last question to this set of witnesses. I call Keir Mather.
Thank you, Chair. Chief Constable, I had a question referring back earlier to the issues you raised around rural crime, which I think is becoming a particularly pernicious issue facing communities, especially when it comes to things like off-road bikes, fly tipping, the theft of farm vehicle equipment. Could you speak to how any of the provisions in the bill will allow police forces to better tackle rural crime as a whole?
So I agree entirely with the point in respect of rural crime. We need to acknowledge that the rural economy, the custodians of our countryside, and how important that is, and policing needs to do more in respect of bringing those to justice. There is, if I'm not mistaken, a provision in the bill relating to the point about the swift recovery of electronic devices, which I think enables us to do so more swiftly in respect of crime, which is the proceeds of some sort of rural crime offence as well. This is a category of crime where the proceeds are often disposed of very quickly to other parts of the country and indeed overseas. And very often, of course, those pieces of equipment or devices also have tracking capability. So anything which enables us more swiftly to respond to those and recover that property gives us a much better chance of bringing to justice those offenders than has been the case in the past, and also is likely to have a considerable deterrent value for organised crime groups and the opportunistic criminals too.
Thank you. Thank you, Chair.
Yeah, I think
The provision for seizing vehicles without giving notice now, without going into detail, I think that would definitely assist.
Yes.
probably squeeze one more quick one in, David.
Thanks very much, Chair. I just want to quickly associate myself with the member for Forest Dean and thank you for your service. And Tiff, I had a question. When we met in January, I was very grateful for the briefing. Part of what we discussed was neighbourhood policing, which is a key theme in this bill. Could you offer any assessment you've done of this bill's effectiveness in helping neighbourhood policing?
Neighbourhood policing is the bedrock of policing. It's something that I've always believed in, and we've discussed that privately. The officers that are out there, the police community support officers that are out there working with communities, and this bill, I come back to what I said before, this bill will go some way to bring us in line with how society is changing so that we can actually use the laws to keep the public safe. But again, it comes down to what is the investment in policing for us to be able to enact those laws. And it comes not, and when I talk about investment, it's about people, it's about systems, it's about infrastructure.